We'll start with Hustler magazine. We'll start with the Hustler magazine versus Jerry Falwell, page 96 of the resource book. What happened in this case? It's a parody advertisement of this popular Italian, it's not whiskey, it's I don't know what kind that is. It's alcohol, it's a hard liquor brand, Campari. And in this advertisement, well, in this parody advertisement, Jerry Falwell talks about his first time. So Campari, the producer of Campari ran a series of advertisements where celebrities come out and talk about their respective first time of drinking Campari. So I had my first shot of Campari, on a yacht, right? Or I had I first drank Campari, at this famous bar. So Hustler magazine wanted to basically parody that by having Jerry Falwell, who is probably one of the most respected figures in modern American history, without any scandal. He is a pastor, Christian pastor, who didn't have any scandal at all. Many Christian pastors, many well-respected Christian pastors, have had scandals, have shown political bias, have been linked to corruption. Almost all powerful Christian leaders have disappointed us, but not this one. He was very well respected at the time and has been respected since then as well. So Hustler magazine, this is an adult magazine that features pornography basically, and they did a parody of a Campari advertisement by having Jerry Falwell appear and talk about his first time of not drinking Campari, but of having sex. And in the advertisement, he's featured as talking about his first time of sex, which in the advertisement he had with his mother. So this is, one of the worst epithets that you can throw against another person. Mother F, right? So he filed first lawsuit for defamation. What do you think about that lawsuit? This is not about defamation. This is about infliction of emotional distress. What do you think happened to the lawsuit for defamation? Or should happen to lawsuit for defamation? What would happen if it happened in Korea? Again, all the laws about speech are subject to the constitutional limits. So when you interpret the laws regulating speech, such as defamation, you should interpret it in a way that is consistent with the constitutional limit. What is the constitutional limit on speech regulation? Clear and present danger. We talked about it. Right? The same principle applies across the board. So we should think about what is that clear and present danger presented by this advertisement, this parody advertisement. Since it's defamation, yes, it must be his reputation at stake. It must be his reputation that's injured. But you should ask whether the threat or the damage to his reputation is that clear and that present. Present is some people misinterpret present. present을 현존, 현재 이렇게 번역들을 했는데 사실 잘못된 거예요. present은 여기서 present은 임박하다는 뜻이에요. 임박. 곧 다가온다. 네. 그래서 영어 표현에 okay, I'll go out presently. 이거 내가 지금 나간다는 게 아니라 곧 나가겠다. 그러니까 그런 뜻도 있는 거를 지금 모르고 현존, present, right now 이렇게 번역을 하는데 사실은 피해가 immediate하다. 그래서 그 앞에 if you read Brandenburg, if you read this Dennis case, you know, the justices keep talking about immediate harm. Right? So if you want to translate, I mean, the better translation will be 명백하고 임박한 위험. Right? But anyway, so what clear and present harm is threatened to Jerry Fowler's reputation by this parody advertisement?
Professor, like, shouldn't be the keyword parody, and no one should be supposed to take it seriously?
Exactly. So that's what happened to the defamation. If you watch the movie, oops. If you watch the movie Larry Flint, he was a legendary figure in American pornography industry. Hustler was his main publication. He was thrown into jail many times for publishing and distributing pornography magazines. And some of the groups at the forefront of persecuting him were Christian groups. They thought that pornography is a crime, it corrupts people's minds. So his life was, but he just kept publishing, and he gave speeches traveling the country, telling people why people should be allowed to enjoy pornography, and the real harms were actually done more by Christians than pornographers, because many wars massacring people were fought for religious reasons. And many massacres, Holocaust took place for a religious reason as well, was backed by religious reasoning. But anyway, so he was a legendary figure, so there is a movie made about him. And because this lawsuit was one of the highlights of his crusade for freedom of speech, this lawsuit is very well featured. And there, the focus is more on the defamation lawsuit than infliction of intentional infliction of emotional distress. And there's a scene where the lawyer for Larry Flint or Hustler magazine puts on the stand a witness, a friend of Jerry Falwell, the pastor, and keeps asking, "Oh, how well is he respected?" Well, then he goes through a list of reasons, and a list of colorful language. The most colorful language that can be used to really command a person, to show respect to a person. So after Larry Flint's lawyer let the witness speak so many good things about Jerry Falwell, at the end he asks, so would people believe? So if he's so well respected, would people believe? Would people think that he actually had sex with his mother? And the witness says, no. And then the lawyer asks, okay, well, after reading this advertisement, do you think that people now believe that he had sex with his mother? Witness says, no, they'll never believe it. Now, that testimony, Jerry Falwell's friend's testimony, was actually used against his lawsuit because, yes, no reasonable person would actually think that he had sex with his mother. So there was no clear and present danger to his reputation. So defamation lawsuit was, on defamation lawsuit, Jerry Falwell lost. Think about, just to put you immersed in this algebra, this mathematics of defamation. Think about reputation. What is reputation? 우리 보통 이제 평판이라고 번역하죠. What is reputation? Where is your reputation? Where is my reputation? Do I carry it with me? Is it in my heart? In my mind? Where is my reputation? Yes, other people's minds, right? So to recover damages, to win a defamation lawsuit, you have to show that other people think less of you because of what they heard or what they read about me, right? And that has to be some factual allegation. Okay, this is one term that you have to be very familiar with. Allegation. 적당한 번역이 없는데, 주장은 주장인데 견해를 펼치는 게 아니라 사실적인 주장. 사실적이라는 게 진실에 가깝다는 의미의 사실적인 게 아니라 진위를 가릴 수 있는. 예를 들어서 저 사람 사기꾼 같다. 이건 견해죠. 저 사람 실제 누구 사기를 쳤다. 이거는 사실적 주장이죠. 그건 이제 allegation. 예. 그러니까 argument하고 다른 거죠. argument. So to win a defamation lawsuit, there has to be allegation, okay? Factual assertion. Again, here factual doesn't mean closer to the truth. That's not what's meant by factual. What's meant is it has the potential, it has the structure, it has a semantic structure. semantic. 자꾸 수렁에 빠지는데 한 단어를 설명하려고. 그러니까 의미론적으로 it has to be a semantic structure that allows verification. 그러니까 진위를 따지는 것이 가능한 그런 의미론적인 구조를 가지고 있다는 의미에서 factual이라는 거예요. So it has to have allegation that will be believed by other people so that they now think less of me or they respect me less. All right. So that's how defamation lawsuit was lost. So Jerry Falwell filed another lawsuit saying, okay, maybe this is not defamation, but I'm hurt. So he filed tort of, so if you look at the left, the first paragraph on the left column on page 96, on the first paragraph toward the end, it says, for tort of intentional infliction of emotional distress. tort. 민사불법행위죠. 네. Okay, well, now, if damages, if court orders, or if a judgment is handed out against Hustler magazine for producing this advertisement, it will be restriction on their right to freedom of speech, because they'll be financially persecuted, financially penalized for having spoken or having published this advertisement. So, what does the court say about this? So if if someone calls you Mother F, yes, you will be offended. So the question is whether you can recover damages for feeling offended. Now, that offense, that feeling offended, where is that? Is it also in other people's minds? No. This is in you, right? What does the court say about this? If you look at page 97, on the right column, the second big paragraph, it's like middle paragraph on page 97 on the right column, the court says, we must decide whether a public figure may recover damages for emotional harm caused by a publication of an ad parody offensive to him and doubtless gross and repugnant in the eyes of the most. Gross and repugnant. Respondent would have us find a state's interest in protecting public figures from emotional distress is sufficient to deny First Amendment protection to speech that is patently offensive and is intended to inflict emotional injury. So, patently offensive, patently, clearly, 뭐 이런 뜻이죠. 노골적으로, 네, 이런 얘기입니다. And is intended to inflict emotional injury. Well, yes, it was intended, because Larry Flynn wanted to basically somehow get back at Christian groups. So he took the most respected Christian figure and made a mockery of it. So it was certainly intentional. What does the court say about this? Page 98, the second paragraph, the page 98, the left column on the second paragraph, it says, the sort of robust political debate encouraged by the First Amendment is bound to produce speech that is critical of those who hold public office or those public figures who are intimately involved in the resolution of important public questions or by reason of their fame. Shape events in areas of concern to society at large. A few lines down, such criticism inevitably will not always be reasoned or moderate. Public figures as well as public officers will be subject to vehement, caustic, and sometimes unpleasantly sharp attacks. So, what does the court mean when he says, when they say public officers will be subject to vehement, caustic, sometimes unpleasantly sharp attack? So, you see, if you want to find examples in Korea, a couple of former presidents have been likened to animals. Chicken, and a mouse. These are very unpleasant for the presidents themselves, and the court is saying, public officer should be able to withstand that type of attack. So why is that so important? Why is it so important to allow to allow the public figures or public officers to be mocked and ridiculed? Why is it important that we have a right to make fun of public officers? Okay, but freedom of speech is, but why particularly do we have more freedom of speech against public officers as opposed to other people? So if you look at page 99, the court themselves give examples of those unpleasant attacks. So page 99, the left column, the bottom paragraph, several famous examples of this type of intentional injury speech were drawn by Thomas Ness, probably the greatest American cartoonist to date. In the pages of the publication, Ness conducted graphic vendetta against William Tweed and his corrupt associates in New York City's Tweed Ring. And another writer explains that the success of the Ness cartoon was achieved because of the emotional impact of the presentation. It continuously goes beyond the bounds of good taste and conventional manners. Actually, one okay, one other example is a paragraph following. Despite their sometimes caustic nature from the early cartoon portraying George Washington as an ass, donkey, right? Down to the present day, graphic depictions of satirical cartoons have played a prominent role in public and political debate. Ness' castigation of Tweed Ring, Walter McDougall's characterization of presidential candidate James G. Blaine's banquet with the millionaires at Delmonico's as the royal feast of Belshazzar, and numerous other efforts have undoubtedly had an effect on the course and outcome of contemporaneous debate. Lincoln's tall and gangling posture, Teddy Roosevelt's glasses and teeth, Franklin Roosevelt's jutting jaw and cigarette holder have been memorialized by political cartoons with an effect that could not have been obtained by the photographer or the portrait artist. From the viewpoint of history, it is clear that our political discourse would have been considerably poorer without them. So this is a political debate, talking about public officers as political. What is politics? Well, it changes the way resources are distributed. It changes the way people are rewarded and penalized. And as people who are affected by resource allocation and dispute resolution, affected by the politics, they have no power other than voting on people who make the decisions. Yes, ordinary people can exercise their power during election, at the time of election, by voting for or voting against the officers they like or hate. But are they supposed to keep silent after the election? These are the people supposed to represent ordinary people. I mean, the officers are supposed to represent the wills of ordinary people. And they should be able to monitor the activities of their representatives and give voices, I mean voice their concerns if the elected people are not doing what they said they will do. So sometimes for ordinary people in democracy, that's sometimes the only way to send a message to the people who acquire the power through election. Because you know, when you elect somebody, you don't like write on the ballot. You don't write, okay, I vote for you on the condition that you will lower college tuition, right? You just vote for him, vote for her. No condition attached. So the only way that you can actually deliberately participate in the politics by showing support or opposition, support for or opposition against elected officials. And so now we establish the importance of criticizing public officers. Then they will say, oh, okay, you can criticize public officers. But do you have to be that colorful? Do you have to be that outrageous? Do you have to actually ridicule at that low level of describing someone as Mother F? What's your response to that? Well, as I just read, it is the emotional impact. That is important. It is the emotional impact of satire. That's important for the political debate. If you look at page 99 on the left column, second paragraph from the bottom, political cartoon is a weapon of attack, of scorn and ridicule and satire. It is least effective when it tries to pat some politician on the back. It is usually as a welcome. It is usually as welcome as a beasting, and is always controversial in some quarters. That's what satire is for, to be a bee sting. Page 99, on the right column, the bottom paragraph. Respondent contends that the caricature in question here was so outrageous as to distinguish from more traditional political cartoons. The court says, there is no doubt that the caricature of respondent and his mother, published in Hustler, is at best a distant cousin of the political cartoon described above, and a rather poor relation at that. If it were possible, by laying down a principled standard to separate the one from the other, public discourse would probably suffer little or no harm. Okay, so okay, maybe political discourse is not affected if we have one less parody advertisement in the magazine. This one, right? But we doubt that there is any such standard, and we are quite sure that the pejorative description outrageous does not supply one. Okay. What is outrageous? I mean, how do you define outrageousness? Page 100, left column, the top paragraph. The fact that society may find speech offensive is not a sufficient reason for suppressing it. Indeed, if it's the speaker's opinion that gives offense, that consequence, right, the consequences of giving offense, offending, is a reason for according it constitutional protection. You want to hurt another person with words. Well, that is what should be allowed. You should be able to hurt and offend. You should be able to hurt another person. You should be able to offend another person's values, because that's what political debate is about. People opposing abortion frequently call doctors murderers. 살인자라고. Why do they use such outrageous language? Well, to hurt the doctors, hurt their feelings so that they stop aborting the babies. So that's one reason. Okay. Another reason that the court gives is that it is impossible to maintain defamation as a law if we allow this to go forward. If this is allowed to go forward, now who's going to sue for defamation? It's much easier to prove that you are offended than other people think less of you. Reputation damage is much harder to prove. Why would people so let's see. If you look at page 98, the right column, top paragraph. This breathing space is provided by a constitutional rule that allows public figures to recover for libel or defamation only when they can prove both the statement was false and the statement was made with the requisite level of culpability. So that's how defamation law is made. And page 99, the left column, the third paragraph. Were we to hold otherwise, there can be little doubt that political cartoonists and satirists would be subject to damage awards without any showing that their work falsely defamed its subject. Okay. So, if you can sue for intentional infliction of emotional damages, you don't need to sue for defamation. You don't need to prove any falsity. So many satires and cartoons that rely on hyperbole or metaphors will be suppressed, because people will now, I mean, yes, defamation, damages for defamation, damage awards for defamation will be much greater than intentional infliction of emotional distress, but still, lawsuit is a lawsuit. This lawsuit will suppress the cartoonist. What message do you think Larry Flynn was trying to convey through this parody ad? If you look at page 101, that is the testimony. Of Larry Flint himself. Did you want to upset Reverend Falwell? Yes. Do you recognize that in having published what you did in this ad, you were attempting to convey to people who read it that Reverend Falwell was, just as you characterized him, a liar? Well, liar because if he actually had sex with his mother, then he is lying every Sunday in front of his congregation at church. He's a glutton. How about a liar? Yes, he's a liar too. How about a hypocrite? Yes. That's what you wanted to convey. Yes. Didn't it occur to you that if it wasn't true, you were attacking a man in his profession? Yes. Did you appreciate at the time that you wrote okay and approved the publication that for Reverend Falwell to function in his livelihood, in his commitment career, he has to have an integrity that people believe in? Did you not appreciate that? Yes, I did. And wasn't one of your objectives to destroy that integrity if you could? He answers, to assassinate it. That was his intention, clear intention. And yet the court throughout the lawsuit saying discussion on public figures should be freely allowed, even if it hurts the feelings of the public figures. Now you'll see that this is kind of a reverse psychology if you look at it from a Korean perspective. Because the more powerful figure that you talk about, the more restraint you think you should exercise, at least in Korean culture. Because we are one of those countries that have honorific forms as opposed to non-honorific forms. 존댓말과 존댓말 아닌 게 있죠. So it is built in our language that it is ethically correct to pay more respect to power figures. But here, the court is saying the reverse. Powerful people should allow more disrespect to be paid by other people. So we've had this constitutional crisis on freedom of speech, I think, for past 10 years. There was a Twitter account titled this. Read that. This was a Twitter account, and a government agency wanted to take down that Twitter account. Actually, we're gonna learn about it later. 방송통신심의위원회죠. Korean Communication Standard Commission. I was a member of the nine-person body, and we had a discussion, and I had a very interesting exchange. I said, okay, well, that tells me that there are people who are angry about what the president is doing, and they are expressing their anger because they don't have any other power. The election is done, and even if they hate what the president is doing, there's not much they can do but to express their anger. The people who wanted to take down, and they actually took it down, I was in the minority. The majority voted to take it down. The majority said, one of the commissioners said, that's like calling your father Mother F, right? How can you do that? That is inhumane. That's what I felt, that's what I faced, confronted. the real face of censorship. They wanted to protect the power structure. They wanted to protect the existing hierarchy. The reason you should not call your father Mother F, it's not because he has power. It is because he is close to you and you don't want to hurt him. But here he was saying you shouldn't call your father Mother F. I mean, the fact that he used that to justify taking down the Twitter account tells me that what they really wanted to do was protecting the existing hierarchy of power. So the trend continues. Even now, we have a very popular president. This president is not likened to any animal, but there are people who hate it, who hate him, and they use the term like so. 재앙 means disaster. This is the president's name. By just adding a couple more lines, you get name disaster. But even, some of the people who demanded freedom of speech in the previous regime are now saying, oh, how can you do that? We have to take some legal action against the people who are using those terms. As if they have forgotten that they wanted to protect those epithets against the previous president. So some of the Congress people come out and did the press conference saying, oh, the prosecutors should do something about people using this mocking language against our dear president. As long as those people continue in power, I think Korean Constitution does not have any hope. They are talking about constitutional amendment. Well, no matter what the Constitution says, if they're going to continue to believe that criminal prosecution is due against the people expressing anger on the most powerful figure, I mean, if you listen to them carefully, what they're really saying is, because he is powerful, he should not be mocked. Because he's our dear leader, it is a heresy to use epithets against that person. So that is the U.S. Constitution's stance on epithets or insulting or other hurtful language. Now let's go to page 102, Cohen versus California. Here, the bottom of page 102, on April 26, 1968, the defendant was observed in the Los Angeles County Courthouse in the corridor outside of the municipal court wearing a jacket bearing the words F, the draft. What is the draft? Draft is ordinary, it's a layman's term, lay people's term for military conscription. 그러니까 징병을 draft라고요. There were women and children present in the corridor. The defendant was arrested. The defendant testified he wore the jacket as a means of informing the public of the depth of his feelings against the Vietnam War and the draft. Watch the year 1968. At the height of the U.S. involvement in the Vietnam War. Actually, it's not U.S. involvement. It was the American war. They were the main parties fighting the war. So, what does the court say about this? Now, there is a limit on freedom of speech. That is clearly and present danger. So, if you look at page 103, kind of a like middle paragraph. This court has held that the states are free to ban so-called fighting words, those personally abusive epithets which, when addressed to the ordinary citizen, are inherently likely to provoke a violent reaction. Okay. It was, when addressed to ordinary citizens, are inherently likely to provoke violent reaction. What's the language? Inherently likely to cause a violent reaction. Do you feel the clear and present danger? Right? So, and then it's cite Shaplinsky. Shaplinsky is a case where someone gave a very racially charged speech and it was mocking the entire race in their presence. And there, were mocking race, religion, and if actually, I'm not sure if that's the case, but fighting words are usually applied to that type of case, where you say something in their face, intending the other person, intending to trigger some violent reaction, to cause a violence. Now, question is whether this whether these letters in Cohen's jacket, fuck the draft, whether they constitute fighting words associated with giving rise to clearly and present danger. The court says, while the four-letter word displayed by Cohen in relation to the draft is not uncommon, employed in a personally provocative fashion, in this instance it was clearly not directed to the person of the hearer. Okay. So, that's something I wanted to point out. It was not directed at any person. The reason that you can punish or restrict fighting words is because somebody will be terribly offended and will be triggered into a violent reaction. But here there is no somebody. Now, if the jacket said, "Fuck the draft," and he wore it in front of the military officers actually doing the draft, and if the jacket said, instead of "fuck the draft," saying "fuck the drafters," that may become fighting words. But here, I just want you to feel like how much precision there has to be, how much causation there has to be between harm and speech before you can restrict speech. Here there is no specific person. Now, I'll talk about Korean crime of insult a little bit later, but also Korean crime of insult requires a specific target. You cannot insult 20,000 Korean university students. You can only insult a person by person. So a similar analysis is there, but so if it's not fighting words, but the police is saying, this is too offensive. Can there be, it's just offensive to other people to use, this is more offensive than Jerry Falwell advertisement because there is no epithet there. There is no foul language. Here, they use the F word explicitly. See, Jerry Falwell advertisement did not use the term, but here, they actually use the term, use the offensive term. So now the court goes into whether using offensive language can be a new basis, right? A different basis for restricting speech. The court says, if you read page 105, 104, 105, the third paragraph from the bottom, page 105, third paragraph from the bottom. We cannot overlook the fact that much linguistic expression serves a dual communicative functions. It conveys not only ideas capable of relatively precise detached explication, as much for their emotive as their explication, but otherwise inexpressible emotions as well. In fact, words are often chosen as much for their emotive as their cognitive force. We cannot sanction the view that the Constitution, while solicitous of the cognitive content of individual speech, has little or no regard for that emotive function, which practically speaking may often be the more important element of the overall message sought to be communicated. Okay. So there is that emotive function. And then, in the same vein, we cannot indulge the facile assumption that one can forbid particular words without also running a substantial risk of suppressing ideas in the process. Indeed, governments might soon seize upon the censorship of particular words as a convenient guise for banning the expression of unpopular views. See, language, we protect freedom of speech not just so that ideas can be freely exchanged, but also emotions can be freely exchanged. He is angry at the draft, and he wants to show that anger. He wants to show the depth of that anger. I mean, probably the US is one of the most individualistic country, and that country is forcing its own people not just to work, but work to kill others or be killed, because that's what happens when you go to war. Kill or be killed. Kill or die. I mean, even forced labor will be insulting enough, will be angering enough to Americans. It's not forced labor, it's forced death or forced murder of another human being. That's how angry he is, and he wants to show that anger. That is the value of speech, conveying that anger. So, if you ban certain words for being offensive, then we are banning the ideas or the feelings associated with those words. So the state will become the thought police, 사상경찰. It's not just words that they are banning. It is the feelings contained in those words that the government will be banning. So some people will say, okay, I mean, you can criticize the draft. Why do you have to use such strong language, such offensive language? Why don't you say, instead of fuck the draft, say, I don't like the draft? All right? I mean, instead of using this Twitter handle, why don't you say, I do not like 2MB? Well, that's not how the word works, right? That you cannot use angry language means you cannot be angry. If you want to protect people's right to be angry at the president or at the draft or any other government policy, then you should protect their right to express that anger. What's an idea for if it cannot be expressed? So that is the again the stance of the Constitutional Court, the stance of U.S. Supreme Court on the law form of language. Now compare that to Korean law of insult. Now this is very important for any student of constitutional law, because every year we have about 200,000 criminal indictments for all the crimes put together in Korea. That includes murder, battery beating, right? Battery, rape, kidnapping, prostitution, even copyright violation. All crimes. I mean, we are a very law-abiding citizens in a country of 50 million people. 200,000 indictments each year. That means most of us are law-abiding citizens. But out of that, 10,000, that's what? 5%. Right? It's 5%. 5% of all crimes, all criminal indictments, indictments가 뭔지는 알죠? 기소. 네. Is for the crime of insult. That's how much resource we are spending to protect people from being insulted. What's the definition of insult? There's no further definition, just insult. It's a crime to insult another person. But where does the feeling of insult come from? So, this Hustler magazine in Korea will be criminally indicted. This person using this foul language, fuck, will be easily indicted in Korea for crime of insult. And actually, that's what the crime is. That's how the crime is used. So many insult accusations come from police officers in line of duty. Because police officers, when they arrest someone, the person being arrested usually claims innocence and starts verbally attacking police officers. Because physically, he's outpowered, is overpowered, so he can only get back in words, in speech. And many people participating in demonstration on the street, they are arrested by these young military police, who are like younger than you, right? The people who are in college, who are in college age. And being in Confucius country, they hate to be overpowered by younger people, so they start using foul language, and they get arrested not for participating in illegal demonstration, but for insulting a police officer. So that's how like 10,000 cases are made up. But what is this project of protecting people from being insulted? When do you get insulted? When was the last time that you were so insulted that you lost sleep, you couldn't eat? For me, that happened at the early age of 15, when my first girlfriend dumped me. Really. I mean, it was first love, so it hurt a great deal. And it made me wonder, where do I lack? Why does she not like me anymore? We were like this every day. We studied together. Yes, we had sex. We engaged all the things that lovers will do. And just one day, she likes another man. Another boy. What do I not have that he has? I felt so insulted. So I did. So to console my soul, I began learning guitar, began singing over the guitar. Really couldn't eat for 3 days. But is that something that the government should feel responsible for? Feeling insulted? I can insult you very easily by giving you C+. People intending, students walking into exam room believing they have done well, get easily insulted if the evaluations are, unexpected. Where does the feeling of insult come from? Well, you have sense of yourself, or your sense of self is up there, but objective evaluation given to you is down here. When there is that distance between your subjective self-assessment and objective evaluation by others, then you get insulted in proportion to that distance. So if evaluation is not a vain exercise, or is a controlled exercise, if it's a true evaluation where things can go any way, then feeling of insult is built into evaluation. What is evaluation? Evaluation, value, attaching value. What is human civilization? Well, attaching value to things. That's what makes us human. Literature, poem, music, what is it? Well, attaching value to things. You go out to see a beautiful mountain and you write a poem about it because you attach value to what you saw. You attach value to the scenery. You pay homage, you pay respect to that scenery by writing poem. You write a biography about a person to share the value you see in his or her life. What is education? Giving value to yourself. And many times that value comes in very strict mathematical formula, unfortunately. GPA. And your value is often reflected in that number. And many times the school that you receive that number from. Evaluation is not just built in to human civilization, but it is human civilization. And all forms of evaluation run the risk of insulting somebody. And whether you are insulted or not depends a lot on your self-assessment, as I said. So, it can run very unfair, it can run into very unfair result. If you see ordinary people and tell them, I think you are worthy of being a mayor of Seoul City. A lot of people will be happy to hear that, will take that as a compliment. But if you say the same thing to politicians running for the president, they'll take it as an insult. If I hear a comment from you, one of you, and if I say, oh, that's a comment worthy of a good student, you'll take it as a compliment. If you say the same thing to me about my comment, Professor, that's a very good comment worthy of a good student, I'll be offended. Self-assessment decides what can be insulting to you. So that's also unfair. Now, everybody knows that. That's why the Korean scholars and Korean judges strongly insist that insult crime is not really about protecting feelings. It's not about protecting people from being insulted, which is really odd because the name of the crime is insult. I mean, why do you have the crime other than to prevent people from being insulted? If you look at the criminal law book, 형법 책 보면, and also if you read the Supreme Court cases, they say, it's not about being insulted, it's about protecting reputation. 그래서 외부적 명예를 보고 명예 감정을 명예 감정을 보호하려는 게 아니라 외부적 명예를 보호하려는 거다. 그래서 외부적 명예라는 건 평판이다. It's not internal honor, internal feeling of honor that we are trying to protect. It's external honor that insult crime is trying to protect. But that doesn't make a lot of sense to me. That doesn't make a lot of sense to me because how do you lower the reputation of another person by how do you lower another person's reputation by calling him names? I mean, calling that person in epithets. If I, like right now, if I call you Mother F, do other people will think of him less? Do other people respect him less because I call him that? You will disrespect me for using the foul language, right? How do you, yes, some people may argue, hearing that publicly in front of other people, so that's why insult crime has this requirement of publicly, hearing the foul language may lower a reputation because people will think, oh, there must be some reason why he's being called the names. By the way, name calling means using epithet. Okay, it's an idiomatic expression. So there must be a reason why he's being called names. He must have done something bad. But do most people think that when somebody is being called names? Do most people think that, oh, there must be reason? Or, do a substantial number of people think that, oh, it's just so rude? That person calling names must be a really bad person. It's not clear, right? It's not clear who is being damaged and what is being damaged. That will not withstand the test of clear and present danger. What is being clearly damaged is your feeling, not your reputation, when you hear epithets thrown at you. I see the good intent. What the criminal law scholars want to do is they want to keep the crime and yet defend it as constitutional. But it's impossible to keep the crime if you remain true to the constitutional right to freedom of expression. Because clearly this is not a crime protecting reputation, it's a crime protecting feelings. Some people are saying, oh, it says external honor, 외부적 명예. And that's what German law books say. And we follow German system. And Germany has a crime of insult as well. There's nothing wrong with keeping the crime of insult as long as it is narrowly interpreted to protect just reputation, not feelings. But I think there was mistranslation there, because if you look at German law books, the crime of insult came into being pre-industrial age, like near the end of 1700, so early 1800. What happened was all these children of nobles, nobilities, when they thought they were offended, they would get into duels, 결투죠, 결투, and kill one another. And the social cost of, taking care of people being injured begin to rise. So France banned dueling as a crime in the Napoleonic Code. France still has that law. Dueling in France is a crime. Germany, they took a typically German approach. They said, okay, if you are offended, come to court. We'll decide who acted, who behaved in violation of, in violation of the standard of nobilities. So back then, it's like some of the cases that were brought to the court for insult was ludicrous. For instance, one noble invited another noble, and the guest was getting off the chariot or whatever, the wagon, right? Carriage. Because carriage is like above the ground, you had to either have some stool so you can step on, or a servant had to bend down so that the noble can step on the step on the back. Didn't have a stool, didn't have a servant. A servant was standing, but he didn't offer his back, and he felt insulted. So he took the other noble to court for insult. That he's a noble and he was supposed to receive this support in stepping down from the carriage. Because of that, the early German crime of insult had the requirement that the complainant, right? The complainant, 그러니까 고소하는 사람, the complainant had to have external honor. But their external honor was not reputation. It was about whether you belong to whether you are a noble, whether you belong to nobility. Ordinary people could not claim feeling insulted, could not file claim for feeling insulted. Only nobilities could make that claim. And you cannot say, I'm a noble when you are really not a noble, right? So that's what's meant by external honor. It was not really about reputation. It was not really about what other people think of you. It was really your 신분, your social status. Only people with a social status could do this. Now, that requirement of external honor was removed, ironically, during 1930s under Nazi era, because the Nazis were a populist regime. So they wanted to get rid of the relics of the past to gain popularity. So they said, all people, all Germans, not just nobles, can claim protection from the crime of insult. So anyway, that is my theory of where free speech in Korea has gone wrong. We started at 9 o'clock. We went for 2 hours and 5 minutes. We can either go for another 25 minutes or take a break and come back. Okay, we'll take a break. We'll take a break for 5 minutes. Okay, or you can read page 111, 112, 113 yourself. That's not really constitutional, but it's really defamation law. Now, we, so, what you read in those pages will not be too different from what you know about defamation law in Korea. So, distinction between fact and opinion, right? Or allegation and opinion, right? Can one be held liable for defamation for opinion? No, right? You know that. So, assuming that you understand the law of defamation, now we come to New York Times versus Sullivan on page 118. What happened in this case was New York Times sold advertisement space to NAACP. NAACP was an organization fighting racism in 1950s. That's the organization, and you know about NAACP from the movie Simple Justice. There, in the advertisement, they denounced the public officials for suppressing activists fighting for racial justice, including Dr. Martin Luther King. And there, in the advertisement, said he was, so look at the advertisement, the third paragraph. In Montgomery, Alabama, after students sang "My Country, This or Thee" on the state capitol steps, their leaders were expelled from school, and truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus. When the entire student body protested to state authorities by refusing to be registered, their dining hall was padlocked in an attempt to starve them into submission. Sixth paragraph. Again and again, the Southern violators have answered Dr. King's peaceful protest with intimidation and violence. They have bombed his home, almost killing his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and similar offenses, and now they have charged him with perjury, a felony under which they could imprison him for 10 years. So the person who sued was Sullivan, one of the police commissioners in city of Montgomery, Alabama. Okay. Now, he was not mentioned by the name, but he thought that this was defamatory. What is falsity? What is false information? He contended, the bottom of page 118, he contended the word police in the third paragraph referred to him as the Montgomery Commissioner who supervised the police department, so that he was being accused of ringing the campus with the police. He was saying they never ring, they never surrounded the campus. They only entered the campus, they didn't surround the campus. He further claimed that paragraph read is as to the sixth paragraph, they arrested Dr. King 7 times. But he was not actually arrested 7 times, he was arrested 4 times. So there are falsities. That's why the court says, right in the paragraph below, it is uncontroverted that some of the statements are not accurate. Although Negro students staged the demonstration, they sang national anthem, not my count, not my country, this or they. Although 9 students were expelled by the State Board of Education, this was not for leading the demonstration at the Capitol, but for demanding service at a lunch counter in the Montgomery County Courthouse on another day. Not the entire student body, but most of it had protested the expulsion. The campus dining hall was not padlocked on any occasion. padlock이 이제 그 자물쇠로 잠가놨다는 건데 자물쇠로 잠지는 않았다. Although the police were deployed near the campus in large numbers on 3 occasions, they did not at any time ring the campus. Dr. King had not been arrested 7 times, but only 4 times. So there were falsities. Now, these falsities do tend to lower the reputation of the police commissioner, right? Because arresting someone 7 times, then people think the police commissioner was more vicious than he actually is. What does the court say about this? Page 120, the 3rd paragraph from the bottom, third paragraph from the top. We consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. You read this already, right? And authoritative interpretations of the First Amendment guarantees have consistently refused to recognize an exception for any test of truth, and especially one that puts the burden of proving truth on the speaker. Erroneous statement is inevitable in free debate, and it must be protected if the freedom of expression are to have the breathing space that they need to survive. all the way at the bottom, this is the lesson to be drawn from the great controversy over the Sedition Act of 1798, which first crystallized a national awareness of the central meaning of the First Amendment. Although Sedition Act was never tested in the court, the attack upon its validity had carried the day, and the court of history fines levied in its prosecution were repaid by act of Congress on the ground that it was unconstitutional. So Sedition Act, basically, 이게 이제 유신헌법의 그 긴급조치 1호랑 비슷한 건데, look at the year, right? So this is like the emergency order promulgated under the Yushin Constitution of Korea back in 1976, I believe. So you know that the constitutional amendment was pushed by the military dictator, President Park, back then, to guarantee him a lifetime presidency. And part of the Constitution allowed him to make law. Before, law was made only by the legislature, but emergency law could be made by the president only. So people didn't like the Constitution, so people demonstrated against the Constitution, the new Constitution, Yushin Constitution, and the President Park issued emergency order making a crime to criticize the new Constitution. Okay. So Sedition Act is like that. Look at the year 1798. It's like a few years after the Americans won the independence. They made it a crime to criticize the new government. And some of the people were actually criminally prosecuted for criticizing the new American government. It was never, the law itself was, I mean, since then the law was never used. It was never tested in the court because nobody actually, and the law was never used, so nobody contested it. But the court is saying, hey, the reason we effectively repealed the Sedition Act was to allow people to discuss politics. And, you know, one may say, okay, politics, discussing politics is okay, criticizing the public officials is okay, but you have to do it truthfully, right? That's an argument. You cannot spread falsity. That's the argument. The court says, 1, 2, 3, 4, fourth paragraph on page 1201, and in page 120, 121, the court says, the state rule of law is not saved by its allowance of the defense of truth, a rule compelling the critic of official conduct to guarantee the truth of all his factual assertions, and to do so on pain of libel judgments virtually unlimited in amount leads to a comparable self-censorship. Allowance of defense of truth with the burden of proving it on the defendant does not mean that only false speech will be deterred. So, defense of truth. 그러니까 진실 항변이 있으니까 이 법이 괜찮은 법이다 라는 주장은 받아들일 수 없다 얘기하는 거예요. 그러니까 진실 비판을 할 때 진실로 해야 된다라는, 진실로 할 때만 비판을 할 수 있다라는 규칙을 받아들일 수 없다. Under such rule, would-be critics of official conduct may be deterred from voicing their criticism even though it is believed to be true and even though it is in fact true because of doubt whether it can be proved in court or fear of the expense of having to do so. Right? So 진실이 아니면 명예훼손으로 손해배상을 이렇게 많이 물을 수 있다고 하면 진실도 두려워서 얘기를 안 할 거다. self-censorship이 뭐냐면 자기감열이라는 게 뭐냐면 법적으로 틀림없이 말하는 게 합법적인데도 말을 아끼게 되는 거. 이게 self-censorship. 그래서 진실이기 때문에 절대로 명예훼손 문제가 안 생기는데 명예훼손 문제가 생길까봐 말을 안 하는 이런 일이 있어서는. 자, 오늘 여기까지 하겠습니다. 여기까지 하고 데포메이션을 조금 더 하고 초상권 프라이버시, 다음 시간에 초상권 프라이버시까지 할 테니까 소스북 162까지